we all thank you for your efforts, and we're going to try and get this to the finish line.
Thank you, sir. Mr. Rasmussen.
Thank you, Your Honor.
Sure.
Yes, sir. Thank you for being here. It's been a long time. And, you know, I learn a lot every time I go to trial.
Yeah, sorry, we're having part-time hearing, sir.
We just need you to speak up.
I need to speak up. Well, that's weird. But I'll do so. Hanna now shares, understand what I'm saying here, all the compensatory damages with Real Water. Now, what does that mean? Does that mean you just get to double? No, you still have to find a number. Okay? You still have to come to a number. But Hanna is now sharing that number. Okay? Punitive damages is different. We'll get to that eventually. That's separate. But with regard to the damages that these plaintiffs suffered, Hanna shares with Real Water on that. Okay? Further, I want to go through the numbers that Mr. Odou, no, I said that right, Joel, didn't I?
You did, yeah.
Yeah, we've known each other.
Only 20 years.
You think we're in a club of some sort. We're not. It really isn't, but I have known Joel for quite a while. Can I go through those with you real fast? The first one that Mr. Odou talked about, or excuse me, the third person talked about was Mr. Bottiz. Talked about medicals, futures. We agree with the numbers that Mr. Odou put out here. Mr. Belsky, we agree with that number. Okay? It means we don't double the number. We're not going to double the past medicals. It's staying right where it's at. So also we believe that past, future physical and mental pain, suffering, anguish, and disability, and permanent injury, we agree with that $500,000 figure. Okay? We're going to share with that. Okay? You need to make sure you understand there is no instruction here about apportioning. Okay? In other words, you're going to say, oh, we want to do this for this amount of it, and we want to do this amount for my client, Hanna. You can't. It's a number. Okay? Ms. Arnone, we agree with that number. Mr. Hugh, we agree with that number. And Ms. Ryerson's heirs, we agree with those numbers. Okay. To the people that Mr. Odou did not give a number to, we'd like to go ahead and give you a number. Okay? That's Mr. Keith Haley. And then like the other people, we're going to give you a number very similar to the number that has been given in this case. And that's $500,000 for the pain and suffering, plus medicals and future. $500,000 for the rest. With regard to Orion Gallagher, we're going to say for the two parents, a total of $1 million. Okay? You can decide whatever to do with that. Okay? I don't want to repeat because there's no sense in going over it again. You've had to listen to us for way too many days. that's not going to be something that I want to do and take up that time. All right. So what I just said is that we're sharing. I've offered you a couple of different numbers for the first two plaintiffs that Mr. Odou talked about. And I also told you that with regard to punitive damages, these things are separate. Okay? You have to find a separate number for Mr. Odou if you find a number at all. And he's asked you to say no. With regard to Hanna, we're going to say please find no. Why? Mark, you can put up the slide on hydrazine. We put up this evidence with Dr. Najim and Dr. Babcock. Hydrazine degrades. That was not disputed in this case. So when you're looking at the clear and convincing evidence, it's clear. It should convince you of something. What? That when Blaine Jones made concentrate, he wanted it negative 550. And his testimony was generally always right there. Always right there. Every time he made the concentrate, it was always right there. Then, every day after that, this is what Dr. Najim said, and this is what Dr. Babcock said, it goes down every day. Now what the plaintiffs are trying to tell you is that, oh, it's because it was inconsistent because the meter was defective. It went down because the hydrazine is degrading. It must logically, chemically go down because that's what hydrazine does. It degrades. I can't force it to stay the same. That's what Dr. Najim said. That's what Dr. Babcock said. It must go down. It's a chemical, right? It's not only it's a lot of chemistry. It's the science of it. Pretty simple. So this was the range that they wanted at Real Water. We didn't pick that range. We had no idea about that range. There was no consultation with Hanna. Hey, what's a good amount? Because number one, and it's already been, how many times I've said this, the ORP meter can't measure hydrazine and can't detect hydrazine. So when it gets into this range, why is that? If it started here and it ended up in here, was it because of meter or was it because hydrazine, by the laws of science, must degrade? I can't stop that. What's the determining factor in that? Time. Right? 1 day later, negative 549. 2 days later, 540. I don't know. Okay? What we do know as well is that, what did we find from all the testing done of the Real Water products? Hydrazine was found in every one of them. Mr. Odou has just told you, hydrazine should not have been in any of these products. I agree. They shouldn't have been. The plaintiffs agree. I agree. These people got sick from it, and it's too bad, and we feel bad that that happened. It should never have happened. We agree. But here's the reason. Hydrazine degrades. So they come along with a meter. The training of the Real Water employees, I'm not sure that it's clear and convincing to me that it was always great training. And it kept going down until Casey Aiken gets it from concentrate that was probably made in the end of 2019, maybe January 2020. He uses that in September 30th, October 1st of 2020. So we're talking 9, 10 months after. That means that that hydrazine had degraded for 10 months. And every day it goes down. And then he gets this reading. Did Blaine Jones instruct him, hey, get another probe out. Hey, get another meter reading? No. Blaine Jones, who says he knows how to oxidize the probe, said, do what? Add more concentrate. Is it at that time now we're responsible for hydrazine degrading and then they put more hydrazine in? This goes to punitive as whether it's clear and convincing to you that we should be punished because of the laws of science. Is it clear to you now that the ORP meter was the most important thing and the only thing that read things? Please show the videotape a second. It's going to take a couple minutes. Let me start with this out. Remember Mr. Desicel, he was right here. He was the plant manager. He was the super over everyone on their line. At the same time that Mr. Belsky had drank this water. In and around that time. Okay? We show that go, please. Thank you, Marty.
You use the pH test kits, or did your guys use the pH test kits?
The employees on the line, because that was part of their job, to check the TDS and the pH levels to make sure they were right at what they should be.
Did you train your guys on how to use that pH test kit?
They already knew. All I did is make sure they stayed proficient at what they were doing.
And did you have to train them on the TDS kit?
TDS? No, they already knew.
What's TDS stand for?
Total dissolved solids.
What if anything happened, you did a reading with your TDS meter? What would be the result of that?
The result is what?
You used the TDS meter, correct? What were the results if there was something that was not completely dissolved?
You know, I don't remember what the parameters were, their upper or lower control limits were. But I would stop, we would find out why our TDS is too high or is too low or whatever. But we would stop. Now, it's been 5 years. You gotta understand, what was the actual, what we did, I don't remember.
But you don't know what an ORP meter is?
No, I do not.
Thank you.
Mr. Desicel testified he'd never seen an ORP meter, never knew how to use one, never saw the one that was here. This is the supervisor for almost a year. Is the ORP meter really the determining factor? If they're making water and they're not taking ORP readings and they're selling that on the market, I'll leave you that question to answer. Because you're making a lot of answers right now. Can we please bring up Joel's slides on clear and convincing? I think there was one before that, Joel. It was, since you've already seen it, be more familiar with it, it's a lot easier to do that than me bringing up the jury instruction.
Jury instruction 48,
Yeah.
if that's easier.
Or if you want to go to his slide, is what I was suggesting, that way we're not. And then we'll go to the next one. Okay. I want to talk to you about this words. Remember, the standard for finding liability, for instance, you know, did we do something wrong, or is preponderance of the evidence, 50-49, right? 51-49. This is a higher standard, okay? It's not reasonable doubt. Reasonable doubt is something they use in criminal cases, right? I have no reasonable doubt that there's a, or let me say that again. If there's a reasonable doubt, you can't convict, okay? That's not this. But it's not preponderance of the evidence. So let's go over. Clear and convincing evidence is that measure or degree of proof, in other words, the burden of proof that the plaintiffs have provided for you, which will produce in your mind a firm belief or conviction as the allegation sought to be established. It is an intermediate degree of proof. You need this for punitive damage. If you don't have this, you can't award punitive damages. This is the law. Who did we tell you was going to give you the law? The judge. Is the plaintiff going to give you the law? No. Am I going to give you the law? No. This came from the judge. Okay? Being more than a mere preponderance, it's got to be more than that, but not to the extent of such certainty as is required to prove an issue beyond a reasonable doubt, which is what I just said. Proof, the burden, by clear and convincing evidence, is the proof which persuades you that the truth of the contentions is what? Not lowly likely, not somewhat likely, not kind of likely, not maybe it'll be likely, highly likely. Highly likely that hydrazine doesn't degrade? Two experts. Plaintiff's expert, Dr. Najim, our expert, Dr. Babcock. Hydrazine degrades. It's going to change every day after it's added in the concentrate with those Russian titanium tubes. And the next slide, please. Just the next one and this one. Next one. No, I guess we're probably the ones before this.
Yeah, the other way.
It's the other way. Can we go up instead of down? Thanks. This is the one that I want to make sure you understand some things. Mr. Parker talked to you a lot about what? About Hanna. Well, Hanna is this Romanian company, it's this other company, and it's this company, it's that company, it's all this big conglomerate of companies. At this time, you are to decide only whether any defendant engaged in wrongful conduct warranted an award of punitive damages against that defendant. Hanna is the defendant in this case. Hanna is the defendant in this case. Real Water and its entities, which they keep talking about, which they say the name, is a defendant in this case. Milwaukee Instruments is a defendant. Romania is not here. That defendant is justified by the punishment and deterrent purpose of punitive damage under the circumstances of this case. If you decide an award of punitive damage is justified by clear and convincing evidence that it's highly likely, you will later decide the amount of punitive damages to be awarded after you've heard additional evidence and instruction. So you're getting some more instruction if you do that. We're asking for you to say, no. Is it clear? Is there clear evidence when Mr. Desitel tells you, I don't remember seeing an ORP meter? Is it clear that every time it was used, every time that the real water went out, it always had hydrazine in it? Was the ORP meter responsible? Go to the next one, please. These are the three, and I'm not sure which one the plaintiff is using now, so I'm just going to have to go over them real quick. In order to find punitive damages, you have to find that Hanna worked in one of these ways. Think what these words would mean in your common sense. Appreciate Mr. Odou's defining that for you from what the instruction is going to be. Oppression. Did Hanna act with oppression? As the distributor, yes, we were the distributor, okay? Yes, we're owned by Hanna and, through a company called SID, okay? Oppression means despicable. Despicable conduct that subjects a person to cruel and unjust hardship, okay? With conscious, we had to have a conscious disregard of the rights of the person. Did we even know? Has there been any evidence that we knew that Real Water, meaning Hanna, did they know? Did they know that water that had not been tested for hydrazine was being sold to the public? No one knew that. They didn't even know it. How could we know that? Fraud. I don't think this is here, but we'll go over. It means an intentional. That means we had to say, oh, we're going to misrepresent something, okay? Deceptive or concealment of a material fact known to the person with the intent to deprive another person of his or her rights or property, that's here, or to otherwise injure another person. We intentionally want to injure somebody with the meter. We intentionally want to injure someone with the meter. Implied malice means despicable conduct engaged in with conscious disregard for the rights or safety of others. Remember what Mr. Parker showed the entire gauge? Remember what we talked about when they did that? It had to do with measurements. If the tire grade reached 0, the wheel's not going anywhere, the tire's done. You can still get a measurement, right? That's all it does. It doesn't tell you if it's safe or not. That might be a different machine. We talked about those, remember? Photometers, gas spectrometers, right? Those will tell you if hydrogen's in your stuff. We can't. So we're not a safety device. Okay? Now, there were things that the plaintiffs, remember when we started, back in my opening, I said you had the following analogy. You've never seen a zebra. You go on a flight to Kenya and I tell you what. Well, here's how you can tell what a zebra looks like. Right? It's going to look like a horse. In your head, oh, I got a horse. Okay. And it's going to be black. I haven't told you a lie. I haven't told you a lie, have I? Two animals come over the hill. One's a zebra, one's a donkey. Which one's the zebra? You've heard one side of what the plaintiffs are slanting everything towards. Everything has to go through the ORP meter. In fact, Will Kemp got up here with Mr. Sandalgio. Do you think it was hard for him to answer those questions? When someone's doing that? I digress. There are always more evidence that you need to take. And you know what I really appreciate all of you doing, and I've watched it. I appreciate that everyone's taking notes. I've appreciated every question that you're asking. I appreciate that you're engaged. I'm appreciating so much that you decided to listen to all the evidence. I appreciate it. I thank you. My client thanks you. We are going to share with real water on the compensatory damages in this case. Okay? But punitives, there's no message, really, for a measuring device that doesn't know it's in an environment where hydrazine is degrading every day. Every day, every moment, every minute, it is degrading. We have no idea. And then to say, oh, well, then it had to be inaccurate because it wasn't oxidized. Casey Aixon said it was stored in vinegar. Mr. Brown said that. Anthony Brown told you that. So is that clear? Is it half clear? Is it a zebra? Is it the donkey? What is this? It's got to be clear, and then it has to convince you, oh, there's no other. There's no other way. That's all it has. That's all it can be. So we're going to ask you to say no with regard to punitive damages against Hanna. Let me remind one more time to make sure that I say it clearly. Casey Aiken takes his measurement before 4 of these people over here drank real water. Blaine Jones told him not to change the meter, not to change out the probe, not to check any of those things. It had been stored in vinegar. It was oxidized. That's what I'm telling you. Because if you're storing it every night in vinegar, how many days you gotta go? Common sense. You got instruction on that. And then what did he say? His instruction to Casey Aiken was pretty simple. Add more concentrate. Now, I don't believe for a second that Lane Jones thought, oh, I bet if there's hydrazine in it, they're gonna get more of it. I don't think he had any clue. I believe Brent Jones, his father, when he said, we had no idea. No one would intentionally do that. I get that. Neither are we intentionally defrauding someone, intentionally committing oppression, intentionally doing things under malice. Thank you for your time.
Thank you, sir. And Mr. Robbins, I think.
Rob.
Every one of them.
Quicker.
No. It'll be real quick. Okay, ladies and gentlemen, next we have Mr. Robbins, and once he's done, we'll hear from the plaintiffs with the last word. And so before we start this last push, I think we should just go to the men's unit and come right back. Sure. We have to do. And so anyway, you're admonished not to converse amongst yourselves with anyone else on any subject matter of this trial, or to read, watch, or listen to the report of a commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio. Remember the social media prohibition. And last but not least, do not form or express any opinion on any subject connected with the trial. So the House is not submitted to Mr. Marshall.
All rise to the report to the jury.
We'll be real quick, ladies and gentlemen.
Jury is clear.
Jury approach, okay. Let's take a quick break.
The exhibit list.
We are on the record.
All right, let's go ahead and set forth our appearances. We'll take our corrective. Kaufman, of the rural water entities.
Scott Rasmussen, Hanna and Hanna Instruments. Rob Robbins from Milwaukee.
And I think Dory has one issue she needs to address regarding the exhibits. Is that correct?
Yes, I've reviewed the exhibit list that's supposed to go to the jury, and exhibit 559 is not admitted.
Okay.
Oh, that's the video.
Yeah,
I think it was admitted as.
it was admitted as 7013,
Are you okay with that?
Yeah.
which I believe is on here. It's listed on here, but also
You
so
did
is
put it- you put it on there.
559.
Can we just stipulate to admit 559 in addition to the
It's the same
defendant?
thing.
I
Yeah.
don't have any videos from plaintiffs. All the exhibits are completely marked and
They were submitted electronically, I believe. That's on one of the electronic ones.
but if it's a video, then it's not on that hard drive because only PDFs can be on those hard drives, no videos.
So, do you have 7013?
I do, and it's
Okay.
marked. All
Alright.
other exhibits are finalized and marked and done.
Yes.
Then can we just, do I need to redo the list without that on there? Can you just
Correct.
cross it out?
No, that has to go away.
Okay, I'll do that and get it sent to you.
Was 7013 on the list?
It is, it's on the list.
Okay. One housekeeping item is really from Maria, that this monitor is now out. I know, look, I know. I'm gonna try to do the special. I'm gonna try to do it, is that all right?
You can do it, sir.
You good?
Good. You can still do.
Thank you. Do we have the laptops for the jury in case they want to, and I know that
chance for plaintiffs want to review it and
Yeah, we've not reviewed it yet, Mr. Odou, but we can certainly do that at the end of closings here.
Great. So are we ready to continue? Mr. Robbins, wherever you're at. Okay. Okay, we can bring them in.
All rise to the jury.
All right, do the parties stipulate to the presence of exhibit?
Yes, sir.
Okay, Mr. Robbins.
Thank you.
You're welcome.
Good afternoon.
I, like everybody else, would like to thank you for your service. We plucked you out of your lives, asked you to come down here. It's never easy. Cases aren't easy. Being a juror is not easy. We all thank you for your efforts, and we're going to try and get this to the finish line. This case is about hydrogen. I would suggest the real shell game going on here is trying to convince you that it is not. Okay? If the evidence that you're going to rely on deals with TikTok videos or when a guy built a pool or the use of how he used the word tons, then maybe you don't want to talk about the evidence. Well, I want to talk about the evidence. So let's get to the evidence. I want to start, and I hate doing this because I know science is, at least for me, it's boring. But I want to make sure that we understand something about where the hydrazine is. So I'm going to go through it really quick, and this will be the last time probably you have to hear it.
The hydrazine in the manufacturing process is made in the production of negative water, which you call negative water, correct?
That is my belief.
Okay. And the negative water is produced in steps 1 and 2 out of those 4 boxes, correct?
Correct.
It's your understanding, I believe you noted in there, that it's made, that this negative water where the hydrazine is manufactured is made 1 to 2 times per year, correct?
That is what I understood from the documents that I received.
And it's my understanding that the orb meter is not used in either step 1 or step 2, is that correct?
I do not know.
You do not know. Did you indicate that in your chart that it's used in either step 1 or step 2?
I did not indicate in the chart.
Okay, thank you. Okay.
Okay, so those are the 4 steps. Okay, so this is step 1 and step 2. That has the titanium tubes in it. They apply the electricity to it, zap it once, zap it twice. That's the hydrazine. That's where it's made. Okay, there is no orb measurement made. They've made the hydrazine. That's it. It says down at the bottom that they call it negative water, or somebody calls it negative water. Negative water is made 1 to 2 times a year. That's it. Okay, no orb meter. There it is. It's stored. Then they, throughout the year, they use this negative water and dilute it with, I think, let's see, we'll go. It's about 2.5 gallons. Getting a little delay here. There we go. They'll take that negative water into step 3, okay? So it's sitting there, it's there for 1 to 2 times a year, they make a batch of it. And then they'll take 2.5 gallons of it and put it into 300 gallons of purified water. That's your concentrate, okay? And you're gonna hear from Blaine Jones here in a little bit that he did take an ORP reading at the end of this step, and he was looking for negative 550, and it generally was always negative 550. He didn't even recall that he ever had to add anything else. So we're through steps 1, 2, and 3, and nothing's been added to the water. Nothing. This is just the manufacturing process for this product, okay? So they've made the hydrazine, they've diluted it into some water, some of it, and they make the E2 concentrate, okay? Step 4 is you take that E2 concentrate And depending on the time of the year, whether it's hot or not, you put either 2 or 2.5 gallons of the E2 concentrate from step 3 into each 300 gallons of the product you're going to actually make. Okay, and then a reading is taken after it's been mixed up and before they're starting to bottle it, and they take a reading with the ort meter, and this is where the testimony has been, they're trying to get the negative 225 to 300, I believe it was. Okay, and then you've heard, oh, they add all this extra concentrate. It's very rare. I would suggest the testimony that has been provided to you, the evidence, in this case, is very rare of the times they've actually had to add extra concentrate, and they generally, the testimony, with the exception of Mr. Aiken, and his one time in the fall of 2020, that they add a small amount, barely any. Okay, Diego said a quarter of a quarter, I think, of a gallon. Okay, but that's the process. Now, you heard Mr. Parker, I believe it was Mr. Parker, got up here and showed you that chart that goes up and down, told you that the only logical reason for that chart in people with liver for all these years was an ort meter. That's the only logical reason. Okay, the ort meter is not even used until step 4. Okay, I would suggest to you using Plaintiffs' Wicked Witch diagram that, when it's first made, the negative water, it's going to be a certain amount of hydrazine in it, and then when it goes to a product and it's manufactured, it's going to be less, and when it ultimately gets to the users, and they ultimately use it, these 5-gallon bottles, if it sit in your house, sit in your garage for a while, it's going to be even less. And we know this because of all the testing that was put up there. They put up the Eurofins testing, they put up the FDA testing. Every one of those readings was different. And it's going to be different because it's degraded. Okay? And that's why you're going to get up and down, because depending on when they made the negative water and when these people drank water and people like them drink water, you got different amounts of hydrazine. Had nothing to do with the ort meter. Okay, that's the inconsistency. Oh, well, look, after 2017 it goes up. Well, maybe they were selling more product. That seemed like a logical reason. It got more popular, they sold it to more people, more people got sick.
At all in this case regarding the amount of product being sold from year to year.
It's a suggestion.
Your Honor,
based on his.
it's gotta be based on the evidence, Your Honor.
It's based on facts. I'll sustain you.
Thank you, Your Honor.
Okay. So, putting that aside, there's no other logical explanation. That seems pretty logical to me. Okay. Yesterday, Mr. Kemp told you that the quintessential witnesses to prove the 2 claims against my client, Milwaukee, was Patty Converse, Diego Mendegana, and Casey Akins. Okay, so let's look at their testimony. Keep in mind, and I think Mr. Parker pointed this out, there's not been a single expert presented by the plaintiff who has the burden that this meter did not work properly. There's no expert testimony. There's no testing. He said, I didn't present it, but I don't have the burden of disproving their claim. They have the burden of proving their claim. If the ort meter didn't work as it was supposed to, wouldn't we see an expert in here? Well, let's look. Okay, here's the 3 quintessential witnesses. Patty Converse. Patty worked from 2015 to 2017. So she's before any of these people were injured to begin with. But this is the gal that was hired as a receptionist, and a month later she became the director of quality control. Okay, he said she wasn't qualified, but she's, I guess, apparently qualified to give opinions on the ort meter. Okay, but is she really? Let's see what she has to say about her knowledge of the ort meter.
You have any understanding as to problems using the ort meter to take negative ort reads? it's been so long that I don't remember everything, but I'm fine.
Okay, that's more than CCOs.
Yes.
Alright, and were you ever charged with taking your readings?
No.
Were you ever in charge of taking ORP readings? No. What does she know about calibration?
Calibrated?
No, the ones that we calibrated was, at that time was Shani, and she was the,
Shady Castillo?
yes,
Castillo? Castillo.
Castillo.
Okay. Okay, she was one of the, you were the director of quality control at the calibrator over here.
Correct.
Alright. And what was her that position?
She was the plant manager.
Okay, so she defers to Shane Castillo, okay, a plant manager. Okay, but yet they played you a clip yesterday saying, oh, it's inconsistent, it takes bad readings. She doesn't know, she'd never taken the readings. She doesn't know how it works. She doesn't know if that was when it was about to wear out, when a battery needs to be changed. She doesn't know. She doesn't have a foundation to say that. Okay, let's look at now there was also a Jeff Desitel, which was just played. I would argue he was in 2017. I don't recall he said much about the old meter. But let's go to Diego Mendigana. Okay, Diego was the one where he had a translator at the beginning of the depot, and then in the middle he kind of asked if he could talk to himself. I don't know if you remember him. And I'm just pointing that out. His English is way better than my Spanish. But let's look at Diego. Okay. So you were told that I think 18 to 20 times it had, inconsistent readings in the 3 years he was using it. Inconsistent readings, and that somehow implied that, the meter was off and they were, having to add all this hydrogen. But this is what he says he does when he gets a meter that's wearing out or is broken.
Were there times that sometimes the meter gave you inconsistent or strange readings?
Yes, sometimes, like different numbers.
Right.
Yeah, but sometimes, so I would let you guys song, and then we'll give you
Another meter?
yeah.
Okay, so sometimes the meter gave you strange numbers, you went and got another meter.
Yeah, we'll see, when we go, or if we calculate this.
Okay. He didn't say he took readings with it when it wasn't performing properly. He said he went, got another one, because they had others available. Okay, standing by. Okay, because these things did wear out. Why? We told them they're going to wear out on the tip card. Okay, if you're going to constantly oxidize the probe, they're going to wear out. You're going to have to replace them. Okay, here's about when the numbers weren't supposed to be, numbers weren't what they were supposed to be in terms of the concentrate. Okay, on the times that you did have to add concentrate. Here's what he actually says about it.
And were the numbers negative 200 to negative 350?
Y los números eran negativo 200 a negativo 350.
Creo que sí, no me acuerdo mucho.
I think so. I don't remember much about the numbers.
If the numbers were not what they're supposed to be, did you add more concentrate?
Y si los números no estaban donde deberían estar, se le agregaba más concentrado.
No mucho, lo que cambiaba mucho era el potasio.
Not much. What changed the most was the potassium.
But sometimes they added concentrate.
Pero en ocasiones agregaban concentrado.
Creo que sí, no sé cuánto.
I think so, a few times.
Okay. When the numbers weren't quite right, Diego Mendigana testifies, did you have to add more concentrate? Answer, not much. What changed the most was the potassium. He doesn't even talk about the concentrate. And then when prompted by counsel's questioning, he sits there and searches and says, I think so, a few times. So this is not a common event that they have to adjust these numbers. Okay? And this is where he talks about how much he does add when he did add a concentrate.
And do you recall how much concentrate you added on those occasions?
Those occasions, not
after step 4 on that diagram. It's after step 4. So we already made the negative, we made the concentrate, we mixed it into a batch, put the normal amount in, okay? And if the few times that reading was not correct, that's what they did. Okay, you've also heard some talk about, oh, it's the ort meter. The ort meter is, I think in opening we heard, it's the sole basis for them deciding how much concentrate goes into the real water finished product. That it's that ort meter. Well, I suggest to you that you've not been shown a chart that says ort meter reading, put this much in it, ort meter reading. They have to use their judgment, okay? They get a reading, that's all it is, it's a measurement tool. They get a reading, and then they decide based on their procedures, their formulas, their manufacturing processes, and their training what to do.
So, really, at the end result, the amount of concentrate that was added to the finished product depended on the negative ORP reading on the Milwaukee meter, correct?
For the most part, yes. However, I will qualify it with, the employees that they would go through certain levels of training to make sure that they're familiar with that process and making sure that they, know how to do it properly and everything. So they wouldn't rely solely on the reading of the meter. They would also use their best judgment.
And what were they trained in terms of using their best judgment?
As it says here, how much concentrate to be added.
Okay, that's how it really happened. Okay, I'm going to jump ahead. Can you jump me ahead to Casey Aikens? Okay, that's 2 of our 3 quintessential witnesses. Let's go to Casey Aikens. Now, Casey Aikens is there in June of 2020 till around, I think, March 2021. Starts out as kind of boxing things up, and when real water moves from the Desert Inn plant to the Henderson plant, summer of 2020, he becomes the lead tech, okay? And this is the guy that you got on there, I think he had a little goatee, whatever you call it, and talked about what he did, and when people started getting sick in the fall of 2020, what happened. So let's listen to some of his testimony.
If the reading was 500 or 600, you'd add more water. Right?
Yeah, I never had to do that. So yeah, I don't know. I'm sure that would be the case.
It wasn't perfect every time, right?
It was pretty close. I mean, as long as you added the correct amount of concentrate, because we had it, Blaine had it to a pretty good science to where when you put, 5 gallons of concentrate into the mix and you put 3 spoonfuls of the potassium, which equaled about 40 grams. I mean, I had a measure that would measure the potassium, and as long as I did the measurements that I had, it would fall pretty close to where it needed to be most times. I mean, I really never had a problem where I had to add this or add that. It was always pretty right on.
In the 2 months you did it, you were never outside the range?
Not really, no.
Okay.
Well, let me think. It was low on not this meter, my potassium reader.
Okay.
That one came low sometimes.
But with regards to the ort meter,
I never had a problem with that.
Okay, so again, potassium popping up. So and we know that he had to add additional concentrate because he told us that when he got this one reading of 130 or 150, whatever it was. But other than that, he can't remember another time where he had to do it. Okay. Now, and I'm going to suggest to you, what was the evidence? How was it ever confirmed that the meter took an improper reading if it was 130, 150, whatever it was? There is no evidence. Hasn't been suggested to you. Nobody's come in and said, hey, look at his logs. He kept logs. He testified about his logs. Where are the logs? Okay? Why aren't they presenting to you this? So inconsistent all the time. Where are those logs? It's their burden. They don't want to show them to you. Okay. After this reading where he did dump an extra, whatever it was, 5 gallons, 2.5 gallons, whatever is in to the mix. Called Blaine Jones. Blaine Jones said, follow the formula, get it to the reading that you need to get. Okay? People get sick.
Anthony Brown starts to look into it. Here's what they did. They don't change the meters. They don't go, oh, the meter's the problem. What do they change?
Complaints came in and then you really got trained up right.
Correct.
You started using the forms and you were given some of the documents and you cut the concentrate back by half.
Correct.
Cut the concentrate back by half, okay? Casey Akins, when Blaine and everybody looks into this, they cut the concentrate formula back by half, okay? After all these people got sick in the fall of 2020. They didn't change the meters, they didn't change how you use the meters, they changed the formula. There was too much concentrate in there. That's why people got sick. This is his recollection of how they stored the meters.
Okay, and so it would stay in there for hours in vinegar if it wasn't in use?
Yes.
Okay? Again?
Do you recall ever using vinegar to be put into the cap that the probe of the ORP meter was placed into during the time you were at the Anderson facility?
I believe that is what we put in there, yes.
Okay. And do you know if, when the day ended, that it was just stored in vinegar overnight?
Yes.
Okay. And so it would stay in there for hours in vinegar if it wasn't in use?
Yes.
Okay, again, from the tip card. The electrode must also be stored in distilled vinegar all the time when not in use. They're following the tip card. They're following the directions. And there's the vinegar.
And as we sit here,
Okay, so those are their quintessential witnesses. Actually, let's go back. There's been talk about Jason Brown's email, okay? Where he says, I was wrong, and his head gets really big. I only remember him saying it once or twice, and I don't think his head got big, but I want to talk about that a little bit, okay? Just to kind of explain this. We would suggest it's a red herring. Can you go back to, let's go back to Mike Bush. Let's talk about Mike Bush a little bit. Okay, here's some of Mike Bush's testimony. Here's being asked about the org meter.
Would it be correct that prior to this email, there were a number of occasions where you felt that your meter was not measured correctly? Yes, it would be an issue, yes, that's just
Okay, asked about the org meters. Oh, yeah, it doesn't work on occasion for the pH. He doesn't even know what he's talking about. Now, is he lying? No. He only worked there for 5-6 months. I don't fault his memory. There's an instruction on that people recollect things differently. Doesn't mean they're lying. But I would suggest that, being there only for 5 or 6 months. He was there, let's see. Let me get the time period he was there. Mike Bush was there November 2018 to May of 2019. That was it. That was the only time he was there. Okay, then, we recall the email to Jason Brown where he's asking about how to calibrate org meters. Here's some discussion about the org meters and what they're doing.
The time practice, the first you know that they did not give you the correct information calendar. That's correct. Those are good. Those kids out to the customers. 5 days ago, the whole job. So the process over there. But you gotta move it on for sure. Right. If they had something you put in there for 5 days, you would have done it. Correct.
Okay, he's talking about getting org meters out to customers. Okay, not to the production guys, not to the guys on the line. Not sure what he's writing that email for, or what these orgs were going to be used for, but he says customers. He also says, I believe this. I think in his former Army, he's saying, hey, they told me I'd do it. Okay. We'll talk about that in a second. here's Blaine Jones talking about how they use the meters as well.
Did you replace the meters periodically?
Yes.
How often?
It would vary based off of where the meter was being used. Many different personnel in the company would have a meter to use for reasons, whether it be the manufacturing process, promotion, marketing, sales, showing customers in stores, different things, different reasons. So depending on the frequency of use, I guess, the more you used it, it would, not last, or it would wear out sooner, I guess is the way to put it.
Okay, so they were using the meters for various reasons. He mentions customers.
And you?
Let's talk about the email now. So let's kind of get to the email. Now, he just said, hey, if you tell me, you give me directions, I'm going to follow it, okay? And we know he sent the email. We know Jason Brown was wrong. He sent them a link to the MA 9025 kit. Okay, this is 2019, February, okay? The kits stopped being sold in summer of 2017. So if he's a rule follower, as soon as he gets this, he's going to say, hey, I want to order those kits, okay? That's what he would have done because he follows the rules. That's the information he got from Jason Brown. Well, he couldn't have got the kits. They weren't for sale anymore, okay? So somehow, some way, the company didn't come to a stop, and we'll figure out in a second, this time frame overlaps with Anthony Brown. We'll figure out what they were doing, and don't know how they got it, don't know how they got the information. Could have been the tip card, use the vinegar, we don't know. But you can, circumstantially figure it out. There's a jury instruction that tells you circumstantial evidence is the same as direct evidence. You get to weigh it just the same. But they certainly didn't shut anything down. They continue to make the product, and we keep hearing from Aikens, and we heard from Anthony Brown. I've lost track of days, but the only witness I called, how they stored these things in vinegar. Okay, but also he kind of mentions it right here when it starts at the top, and the reason you sent the email. Here's what he says.
And the reason you sent the email is you didn't know how to calibrate that order, correct? I did not know. And that was with regards to meters and meters, right? Right, but this wasn't very clear. He was working properly, operation was working right, so verified. You said, there was a longer or something else was in very small, very small bit of small bit. Untreated water, there's bottled water, we had all of the scientists of that was the scientists of that, is that the small bit.
When we see Anthony Brown here in a second, it's a very similar description. But he says, I was telling Blaine about it, okay? He just said, use the vinegar, let it soak longer, and something else, okay? So they figured it out somehow, some way, but he didn't end up apparently buying kits because he couldn't do it. So they figured it out. So it's kind of a red herring issue. It didn't affect, at least I would suggest there's no evidence been presented to you that it affect any batches, any readings, anything. Because they couldn't get the kit. Okay, here we go to Anthony Brown. So you see Mike Bush up on top, November 18 to May 2019. Anthony Brown was there for quite a while. He was the night production lead, August 2018 to June 2019, so the entire time that Mike Bush was there. Let's listen to Anthony Brown and let him talk about the orb meters. Here's how he was trained.
Okay, first of all, did Blaine Jones train you how to calibrate the orb meter?
No.
Okay, how did you find out how to calibrate the orb meter?
I was taught by the day shift leader, Bud, and the director, Shane.
Okay, so Ben and Shane taught you how to calibrate orb meters, is that correct?
Yes.
Okay, so here we have the night shift lead saying how he calibrates the meters. He's about to tell you, but he learned it from Obed, the day shift guy. So we have day shift and Shane, but day shift and night shift. Okay, during the time Mike Bush was there.
And as we say today, your best recollection is you used vinegar to do the calibration oxidation.
Vinegar has some part in it, yes.
Okay. Did they have a bottle of vinegar there, or where'd you get the vinegar from?
They have vinegar, yes.
And did you always store the probe tip in vinegar when it wasn't being used?
Correct. Yes.
And again, per the tip card, stored in vinegar when it's not being used. And keep in mind, it only takes a few minutes to read this reading when it's properly oxidized, not hours to days. And so the rest of the time, it's sitting in the vinegar, constantly oxidizing itself. 160 plus hours a week.
Okay, and then when you would put that into the testing log, do you hit the on button of the ORP meter? Or before?
The ORP is always on.
ORP is always on. So then you put the probe in, and then did it give you a reading?
You mix it around a little bit and let it sit in there a little bit. It would change numbers until it came to a steady number and it stopped moving. So you would have to move the probe in the water for about a minute till you got the actual reading.
Okay. So it stabilized, and then after a minute you got the actual reading based on the response time of about 1 minute, correct?
About 1 minute, yes.
Okay. And did that change over time at any time? In other words, the response time, did that change from 1 minute, become less or more?
No, because you keep the probe in vinegar, and the vinegar was a positive number. So it took time for it to go from positive 500 down to negative 250. So it was just the waiting period of, as that meter was changing numbers, you just sat there and wait till it got to that number and it stopped moving. That gave you your read. So a minute was normal.
Okay. And did you always store the probe tip in vinegar when it wasn't being used?
Correct. Yes.
Here's about the accuracy.
Okay. And what did you do if the concentrate was stronger than what you wanted?
The concentrate was stronger than what we are recommended to have it at.
Mm-hmm.
I would add less of the concentrate to the water.
And what if it was not as strong?
I would add a little bit more than recommended. Well, a little bit more than what was the normal dosage.
Okay. And was this, was the concentrate usually spot on? Was it high? Was it low?
It was very often spot on.
Okay. How often was it high or low?
Very few.
Very few. Okay, spot on. So this suggestion that, the ore meter was so bad and they're constantly adding stuff, nobody's telling you that. They're telling you that, that's argument. That's not evidence, that's evidence. Okay, let's talk about the two claims against my client. Okay. Let's get the easy one out of the way. So the implied warranty fitness for a particular purpose. In that particular purpose, they told you already, the judge made a ruling, was that it needs to be able to take negative readings, okay? Negative ore readings. We've heard from, I don't know how many people talk about them taking negative readings, including their quintessential witnesses, and they all said it takes readings negative. They all, not exactly the word spot on, but pretty much generally spot on for each of them. And we have Blaine Jones talking about when he's doing the E2 concentrate at negative 550. Never has to add anything. It's generally in that range, right around there. Okay? I would suggest to you, case closed on that. Okay? It takes negative work readings. And they were using it properly. They were oxidizing it in vinegar all the time because that's how they were storing it. That's why it works quickly. That's why it works in a minute. And I would suggest to you, there is no breach of that implied warranty, period. So let's move to the other claim. Inadequate warning, failure to warn, okay? We had two witnesses on it, two experts, okay? But we also, as I was going through the testimony, I kept saying, they're following the tip card, they're following the tip card. And this morning, I believe it was this morning, counsel argued to you that, the problems, and he listed up the problems, and it was basically that this information is not in the instruction manual.
okay? It's not required to be in the instruction manual. Their expert's opinion is that's where it should be. Our expert said, doesn't matter as long as you draw attention to what you're trying to draw the attention to, which is negative work readings, okay? Could have put it in there, sure. Could have put it in that user manual, that little tiny user manual, and put it at the bottom of the next item. But that's not what Milwaukee was trying to do. They were trying to get somebody's attention to help them for the negative work readings, okay? So they put this right on top of the box, right on top, it's the first thing. It's got red, bold, or I'll say red capital letters, negative work readings. So if you were using it for negative work readings, they were trying to get your attention. Okay, so let's look at some of the testimony here. We already heard about the negative 5 issue. We don't need to hear that again.
If the, here, and as we sit.
Sorry, well, I moved ahead. Okay, here we go. All right, this is plaintiff's expert, Dr. Motley.
In that sense, the NW 500 meter, I'm just talking about the meter, is a measurement tool, correct? And same thing with the probe, it's a measurement tool, correct?
It's a measuring tool. See whether it's dangerous.
Okay, the NW 500 probe is not an inherently dangerous product, correct? I think I would agree with that, isn't it?
He agrees with that. This is Milwaukee's expert, Dr. Fortenbaugh.
And you did a rebuttal report, an expert report relative to his conclusions, correct? Correct. In his trial testimony, he told the jury, under questions, that the meter itself, in his opinion, was not inherently dangerous. Do you agree with Dr. Motley on that?
Yeah, I mean, there's minimal risk associated with the use of the meter.
Okay.
If it's not inherently dangerous, what safety factors of mine are you going to be having to evaluate?
So, you know, as part of the review, you're going to want to look and see, looking for different types of hazards. There could be a mechanical or electrical or chemical hazards, and you might want to see, are there any safety standards, like an ASTM or an ANSI standard, something like that, that talk about how these products should be or how they should function. Another good way to kind of benchmark things is to look at other manufacturers that make a similar product and see, hey, are we kind of making the same thing here, or are we making something different? So that's all kind of goes into the analysis of how this might have been work.
And in your analysis, did you find anything about this product that would suggest that there was something there that needed to have a safety type warning given to people, to consumers?
No, like I said, there's minimal risk associated with the product, and on the 4 or 5 whatever other ones that I looked at, there's no on-product warning labels.
And do you believe there needs to be any?
No.
Okay. Minimal risk to the user. Doesn't have a saw blade, doesn't have chemicals, not going to electrocute you. Okay, minimal risk. My expert's opinion is you don't need a danger safety warning on there. You need instructions on how to use it. Okay? You don't need a safety one. Here's on the risk issue. Here's their expert.
The NW 500 and the probe that carries a minimal risk to the user, the person using the probe, or using the meter and the probe. Yes. Yes.
Okay. So he's in agreement too with my expert. So, you know, it seems like the big complaint here today that they're trying to argue to you is that the information that we provide in the tip card should have been in the user manual. No requirement. I've not told you there's a requirement that it has to be in the user manual. There was discussion from these experts about quick start guides where you have a user manual, you have a quick start guide, you're trying to get people's attention. So the instructions are not always in the user manual. And I would suggest that the evidence is pretty overwhelming that they were trying to get somebody's attention with this. Really get their attention, not just buried in a user manual. Okay, so
Normally, when I go through the verdict form, I like to put it up on this sucker right here and put it up there, because I'm kind of old school and I kind of go through it. We tried, we can't figure out what's wrong with it, so I can't do that. So we're gonna do it the newfangled way. Can you try and pull it up and go through the verdict form real quick? You've seen it a couple times, so I'm not gonna waste a ton of time on this. Okay, you can go to the next page. Oh, that's tough. Okay, there you go. All right, so number one doesn't have anything to do with Milwaukee. Number two is Milwaukee. Okay, it says, did Milwaukee fail to provide an adequate warning that would have been acted upon? Okay, we're going to ask you to check no on that. We did provide an adequate warning, we provided an instruction manual, and we provided the tip card. And I would suggest the evidence that you've been shown here this afternoon suggests that they were following it, they understood it, they were using it correctly, and I think it worked. It's not matter what I think, it's what the evidence suggests. I believe the evidence suggests that it worked. Okay. So we're going to ask you to check no there. Question 3. If the answer to question 2 is yes, okay, so if you disagree, then you got to go to, if you were to check yes on number 2, you think the warning wasn't adequate, you go to number 3. The second part of this is it has to be that the failure to provide the adequate warning, it has to be a substantial factor in causing the injury of each of the plaintiffs. And I would suggest, again, the evidence we just showed you, that the ORT meter was pretty much spot on most of the time, and occasionally they had to add stuff based on their judgment. And there's been no evidence presented to you that the ORT meter readings that they took when that had to happen was wrong. There has been evidence presented to you of degradation of the hydrazine, time affecting it, temperature affecting it. So they may have got a lower reading on occasion, and they added, based on their training, their procedures, their best judgment, according to Blaine Jones, a limited amount of the actual concentrate. So we would argue that the injuries that the plaintiffs sustained are because of the, as Mr. Kemp called it, bizarre process of how this product was made from John Marlowe in his garage, these titanium tubes, human guinea pig, okay, steps 1, 2, 3, 4 from Dr. Najam. That's why these people got sick, and we know that. You just heard from counsel. They take responsibility. Okay, they're not blaming anybody else. The buck stops with them. So, if you don't check no on number 2, we would ask that you check no, because you have to have both. It has to be a substantial factor. And I wish we had the definition for you. There's a substantial factor instruction in here, and you can look at it. But I would suggest that you're going to have to just decide amongst yourselves what a substantial factor is using the rules. Okay, no, 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 all the way down there. All right, move down. Okay, 4. This is the second cause of action. I think it's even easier. Did Milwaukee breach the implied warranty of fitness for a particular purpose, i.e. was the MW500 ORT meter unfit for measuring negative warp when making alkaline water? They have used this meter for over a decade. Okay, they knew how to use it. They knew when they were wearing out. They had a process of having extra ones around so the guys could grab another one. Even Diego, who said 18 to 20 times he got a funky reading. He didn't say he then took that reading, he said he replaced it. So they knew what they were doing. It took negative warp readings. Blaine said it, Anthony said it, Casey said it. Virtually every witness said it takes negative warp readings, and it's pretty spot on. We would suggest that's a no right there. Okay, if you want to go down, again, if for some reason you say yes to that, the second part of it is it still has to be a substantial factor in causing an injury to each of the following plaintiffs. And if at that point we're arguing to you it is not a substantial factor. Check no on that box. Okay. Next section, okay, these are the damages. I'm not going to get in the middle of it, whatever the defendants say is appropriate and plaintiffs say is appropriate. This is your hard decision. This is where you got to go to work, where we have turned over control to you. So I'm not going to get involved with that. But I am going to give you just one hypothetical. just to kind of put things in perspective. I want you to assume that an individual living here in Nevada, that this individual makes $100,000 a year. And at the end of the year, he managed to save $10,000. Okay, at the end of the year, he's got $10,000 in the savings account. And he's able to do this every single year. I just want you to consider how long does it take for that individual to save $100,000. Takes him 10 years. 10 years. $1 million, 100 years. At $10,000 a year, every year. $5 million takes 500 years. $14 million, 1,400 years. Okay? And I only tell you that because it's an explanation of the value of money. Okay, $1 in this courtroom is the same value as $1 outside these doors. Okay? Now I'm not getting involved. You guys decide what the damages should be, but I just want to put that in perspective for you. And the last issue, go down to the very end of this, please, Mark. Okay, punitive damages. Where's Milwaukee? There we go. Page number 19. We're going to ask you to put no up there. Milwaukee did, I think, a good job. Certainly, they tried to tell the user how to take a negative warp reading. And by all the evidence that we presented to you, I suggest that it was accomplished. Okay? If for some reason we fell short, maybe it should have been in a manual and not trying to draw their attention separately. There's certainly, and let's go to the instruction. I think it's 47, please, Mark. Instruction 47. I'm almost done. You can blow that up where it says oppression. And you've already looked at this, so I'm not going to waste a lot of time. Go down more. Right there. That's fine. You don't have to blow it up. I think that's fine. Okay. Oppression means despicable conduct that subjects a person to cruel and unjust hardship with conscious disregard of the rights of the person. There's no evidence to suggest that Milwaukee did this. Nothing. Okay, they tried to put a card in there. If you think they fell short, you certainly don't check punitive damages. Would be our position. Okay, it's just not warranted. Fraud means an intentional misrepresentation, deception, or concealment of material fact known to the person with the intent to deprive another person of his or her rights of property, or to otherwise injure a person. Intent to injure the other person. No evidence of that. None. None. And implied malice means despicable conduct engaged in with a conscious disregard for the safety of others. I would suggest there's nothing there either. We gave them the card, we gave them the instructions. If you want to point to Jason Brown's email, that was a mistake. That's nothing intentional, it's not despicable conduct, it's a mistake. Okay, at best, that I believe we've shown to you today didn't result in, at least evidence being presented to you, didn't result in improper measurements being taken. Okay, in fact, I think we've shown to you that between Anthony Brown, night shift and the day shift, they were following the procedure on this card. But there's certainly nothing despicable, intentional, trying to injure the plaintiffs from Milwaukee's standpoint. Thank you for your time. I appreciate it. Thank you.
Thank you, sir. Okay, Mr. Pepperman.
Your Honor, and good afternoon, ladies and gentlemen. We are in the home stretch, and this is what we call rebuttal. What that means is it's our opportunity to respond to some of the points that were raised by the defendants. I'm not going to bring up entirely new points. I'm going to just respond to some of theirs. So I'm going to address some, and I'm going to turn it over to Mr. Parker, and he's going to address some of the others, and we're going to bring it home. Because it's rebuttal and because we're responding to what they're saying, sometimes we can jump around a lot. And I think a lot of what they said was predictable. I mean, we knew they were going to come in and they were going to try to discount these people's injuries. I was a little surprised to see how much they're trying to discount, you know, the fact that people suffered a liver failure, that a woman died, that the seriousness of the injuries, that they would propose the numbers. That I was surprised by that personally, but at least we were somewhat ready to respond to that. I was also unsurprised by some of the meter defendants' comments. We knew they were going to come in and they weren't going to defend the product. They were going to try to throw out a bunch of confusing stuff to try to muddy the waters, create confusion here. So I was able to prepare a little bit on that, but I wasn't able to put together the presentation as comprehensively as I would normally like to. And I just want to let you know, one, because I'll probably, be adjusting here as best I can. And I also don't want you to think it wasn't because of a lack of preparation, or that it wasn't worth the time to put in for our clients here, or that I wasn't giving you the same respect that you've given us for this entire time that you've been here, that you've given us in listening and being so engaged in this process. And I'll just echo everyone's comments on thanking you and conveying our appreciation for that. I'm going to try to be quick too, because I know we're at the end of the day and there's a lot to go over, so please understand I'm trying to do that out of respect for time and not to minimize anything here. So the first point I do want to talk about is Mr. Odou's damages, Real Water's argument regarding the damages. I am kind of at a loss for words on this. I found the proposal from Mr. Odou to be insulting, frankly, with respect to these people who've suffered so much and the seriousness of what they've gone through and what they will continue to go through, living every day for the rest of their life, wondering if this terrible disease is going to come back. When? Is it going to be worse? Is it going to be the end at that time? Like Mr. Jones, Blaine Jones said, I think he articulates this very well. I wouldn't wish that on my worst enemy. And to suggest that for the experience of what these people went through, you should give them $500,000, or combine all of them in total, barely half of what Blaine Jones, the Real Water vice president, the defendant's managing speaking agent, said he wouldn't go through again for $10 million. I have no response for that. What Blaine Jones testified to, that's the evidence in this case. You never have in a case like this the type of objective evidence as to these types of damages that we have in this case. It is your job to look at the evidence and come up with these numbers, and that is the way the civil justice system works. Is that responsibility is on the jurors and only the jurors. And we started this with a lot of potential jurors. And it came down over several days to you. You were chosen to be here. I know I can say on behalf of our team and our clients, the plaintiffs in this case, that we trust in your decision. Whatever you decide, I believe that it will be the right decision. I do also want to talk about the heirs. Mr. Odou suggested to you that $5 million $500,000 for each heir would be fair and reasonable compensation, and that what you should award to the family for Kathy Ryerson's pain and suffering prior to her death should be $1 million for her death, $1 million. He acknowledged that you should consider Blaine Jones' testimony. That's something you should consider. But then he asked you just to disregard that. Remember? He said, Blaine Jones, that was emotional. That's emotional testimony. He was just talking out of emotion. He didn't really have this terrible experience with acute liver failure. He didn't really mean he wouldn't take $10 million to go through this. Shane, can we play that clip one more time?
It says, in this sense, it says the debilitation of liver failure, I have been to hell and back. Are we there?
Yeah, it was really, to what extent?
Okay. If we were to go through this again, if I gave you $10 million, would you?
Did that sound overly emotional to you? Or did it sound calm and reasoned? Because that's the jury instructions. And like we said, we trust your decision once you decide. Calm and reasoned. Sounded calm and reasoned to me, very calm and reasoned. One other thing I want to make sure I address is this notion when Mr. Odou comes and says, oh, you should give $500,000 to one of these people for what they went through, for what their own vice president said. He wouldn't take $10 million to go through again. He comes in saying, oh, we've taken responsibility. Oh, we're so apologetic to these people. There's a difference between taking responsibility and accountability and conceding 5 days before trial after hydrogene's been detected in every sample in which it was tested for. And your own expert acknowledges hydrazine was the cause of all these injuries. There's a difference between taking responsibility and conceding responsibility because you're just out of luck. That's what they did. They conceded responsibility because they couldn't say anything otherwise with a straight face. It's not taking responsibility when you are forced to concede fault and then come in here like you're taking responsibility and asking to give these people next to nothing. That's what is going on here. They were facing obvious liability. Now they're trying to take advantage of it to make it seem like they care and they're apologetic while they asked for essentially nothing for these people, for what they went through. To me, it's insulting. Okay, I'm sorry, back to the heirs. Shane, can we pull up the slide on the jury instructions for loss of support, grief, and sorrow? Remember, this is what's guiding your decision on these damages determinations, the jury instructions, not Mr. Odou's insulting request to you. And what we talk about for the heirs is what they've lost in the sense of their companionship, their support, their love from Kathy, from the decedent, and their grief and sorrow for this loss. Now, there are many ways for a person to build a system of support, companionship, and society in their life. And there's no right or wrong way to do it, and there's no better or worse way to do it. The evidence in this case is that Kathy was a pillar of Pat, Rick, and Judy's systems of support and companionship. Neither Kathy, Judy, nor Rick were ever married or had children of their own. The 4 siblings were each other's companions in life. They all regularly spoke and got together. They swam together, spent holidays together, traveled together, visited with Rick together. Kathy was the big sister, the planner, the organizer. And I'm not asking you to take my word for it. I'm asking you to look at the evidence. Make your decision based on the evidence. And I'm not going to play the clips that I had prepared, but I want to remind you of the testimony. Pat Sutherland testified that they were allowed, in the height of COVID, one person was allowed to be with Kathy while she lay in her deathbed at a time. And they took turns, and they were with her as much as they could be, holding her hand at that time. If you remember, she would put on the ice cubes on Kathy's lips because she couldn't drink anything. She would put chapstick on her. They were by their side talking to her. You saw the clip earlier of Judy telling Kathy in her last moments, be with her in her last moments. Now, sometimes this person is a spouse, or a parent, or a child, or another family member, or a friend. Like I said, there's no right or wrong person to have in that situation. But for Kathy, and for Pat and Judy and Rick, it was each other. That's what they have lost. That is what we are valuing here. And when we talk about that, Shane, if you can pull up the life expectancy, this is what you consider. I mean, Kathy was 69 years old when she died. But she had 16 years of life left expected. That's 16 years of family holidays, swimming, getting together, talking, leaning on her for support. That is what they lost. Visits, traveling. Remember Judy's testimony. She said they lived together. Kathy was her person. They lived together like you live with a spouse or a child. That's who they were together. That's what she lost. Judy testified, I was a couple years away from retirement. Kathy was retired. They were looking forward. They were making plans. They were going to travel together. They were going to do things. Now, I'm not suggesting that they would have still been, following reggae bands on tours across the country into their mid-80s. But that's what they were looking forward to doing together. This is what they lost because of them. Because of them. And I ask that when you're deliberating in this, all you do is look at these instructions. Think about the evidence. I don't think you should listen to 1 second for these measly, we killed them, well, here's a couple tokens, a couple $100,000 in exchange for this. It's impossible to put a value on a human's life. It is. But to say for 1 second that Kathy or Pat, Judy, or Rick would take any number of millions of dollars in exchange for not having their sister. $500,000 is just insulting. Moving on to the Gallagher family. Now, conspicuously, there was no number given for Orion Gallagher. I don't even think they could stomach standing up here and saying that you should give Orion Gallagher $500,000 or $1 million or whatever they're saying to ask fair and reasonable compensation for what this baby went through. They can't even stomach that. That should tell you something. They do suggest that you should give his parents $500,000 each. And I just want to remind you what these parents went through. They thought they were forced to do something that no parent should have to endure, to care for an infant suffering from acute liver failure as a result of these defendants' inexcusable failures and conscious disregard. They thought their baby was going to die. They signed the paperwork for his liver transplant at 8 months old. This trial will end, but the care and concern for their child will not. Remember Dr. Hudson's testimony about permanent damage. It is Brian and Camille who are going to be caring for Orion. The burden and fear of this rearing its head again will never go away for them until it does rear its head again. Camille and Brian will be taking Orion to these medical monitoring appointments. They'll be sitting by his side, waiting in fear for the results to see, is it back? Is it the time that the injury reemerges? Every time Orion gets sick or complains about something, even that's normal, they will face the question and fear of whether it's back. You heard the court's jury instructions. The amount of damages is for you. And I'll reiterate, I think the evidence in this case of what these people went through is clear. I think the objective evidence from the vice president of Real Waters saying he would never go through this again for $10 million is objective evidence for you to consider and not disregard. Let me hit on some meter points, points that made by the meter defendants real quick. I think what you heard from the meter defendants was a series of arguments designed to confuse you, distract you from the evidence, and deflect blame to escape accountability in this case. This is Milwaukee's strategy. It's a magic trick or a card trick that uses sleight of hand. The magician wants you to pay attention over here. Look over here. Look at this shiny object over here while the assistant sneaks out the trap door in the back. The magician wants you to pay attention over here while he makes the card move with his other hand. That's the trick. They want you to be distracted, pay attention to something else while they trick you over here. It's the same thing here. They don't want you to focus on the evidence or the jury instructions. They want to distract you. They know what focusing on the evidence and the jury instruction does. That's accountability. They don't want that. They want to distract you away from that. They want to focus your attention elsewhere. But this isn't a magic show. Show you some of the arguments I want to address. Real Water screwed up, not us. Milwaukee 500 is so simple that it does not need warnings or instructions. Hydrazine's already in the water. What I call the accidental oxidation theory. Oh, we were storing it in the cap, but Real Water accidentally oxidized it. Looking at the first one, Real Water screwed up, not us. That's the magic trick. Look over here. Look at them. Don't look at us. But it is not a defense in a product liability case that someone else did something wrong. This is the concept of concurrent cause. Shane, can you pull up the concurrent cause instruction? There may be more than one legal cause of an injury. When two or more products contribute concurrently as legal causes of an injury, the defectiveness of each of said products is a legal cause of the injury, regardless of the extent to which each contributes to the injury. It is no defense that the conduct of a person not joined as a party was also legal cause. So this is concurrent cause. They come together, they act together to produce the injury. They both contribute. Let me show you some examples. If an airbag does not work, it is not a defense to blame the bad driver. The helmet cracks, it's not a defense to blame the bad driver. If seatbelt rips, it's not a defense to blame the bad driver. In each of these cases, a defective airbag, a defective helmet, a defective seatbelt can be concurring causes with the negligence of the driver. They come together. That's what we're talking about here. Even if Real Water admits liability, that is not a defense to the product liability claims against Milwaukee. It's sleight of hand. Oh, look over here. Don't look at us. It's both. You also heard arguments that it's a simple product and you don't need warnings. I'm going to skip over that one. It is, you saw, or actually pull up the warning instruction. Thank you. Look at it. This is the jury instruction. Product manufacturers, distributors, and sellers all have an obligation to provide their products with warnings that adequately communicate any dangers that may result from the product's use or foreseeable misuse. Where a product manufacturer, distributor, or seller has reason to anticipate the danger may result from a particular use and it fails to give adequate warning of the danger, a product sold without such warning is in a defective condition. That's what we have here. Milwaukee knew that this meter was being used to take negative readings while making alkaline water. You saw the evidence. They're adding chemicals to make alkaline water. They know that people are using this meter to rely on how many chemicals they add to drinking water, alkaline bottled water. And they know that if it's not properly oxidized, you're going to get inconsistent readings, or it's going to take hours or days to get to those readings. These users don't know that it's going to take hours or days. It's Milwaukee's job to warn them. They know that this is a danger that can come from their use, in a foreseeable use of their meter, and they don't warn. There's no warnings. You've seen the evidence. There's no warnings at all saying, hey, look out. If you don't oxidize this before negative readings, it's going to take hours or days to get to the proper reading. It's going to give you inconsistent readings. There's no warning of the hazard, period, at all. It doesn't exist. They don't want you to look at that. They want you to look at elsewhere. Oh, look, we put in this tip card that says 48 hours. 48 hours doesn't even properly oxidize this thing. They'd say 5 days everywhere else. There's no warnings whatsoever giving adequate warnings of such a danger. And let's look at the warning definition. Reasonably be expected to catch the attention of the consumer, not in the user manual. Be comprehensible and give a fair indication of the specific risks involved with the product. No indication of the risks, let alone specific risks. And be of an intensity justified by the magnitude of the risk. There's no warning. Next thing they argue is that hydrazine is already in the water. They try to deflect blame by saying, oh, well, look, there's already hydrazine in there. This is another misleading argument and distraction. The meter, like we looked at, does not need to be the only cause. Can you play the slides on Dr. Kosnet's testimony?
Well, the thing I want you to be aware of is a lot of these studies, and I'm going to show you when I mention the studies, and it has to do with what we call dose. Okay? And dose is the amount of a chemical or drug that's taken or absorbed into the body. And we usually express it in terms of the amount the person takes in divided by their body weight. Okay?
This is the testimony on dose. And if you recall, Dr. Kosnek testified, the greater the dose of the greater the dose, the greater the harm. It's more. That's the issue. Yes, real water was putting hydrazine into the water, but the defective meter, the failure to warn, caused more to be in. It's the difference between a rushing river, or a babbling brook and a rushing river, or 1 cup of coffee and 10 cups of coffee, or 1 drink and 20 drinks. That's the difference. That's the meter's role. And finally, on this accidental oxidation theory, storing it in the cap, the tip card specifically says don't store it in the cap. That's their warning. That's what their instruction says in the tip card. So they will put in there, it doesn't work if you store it in the cap. That doesn't oxidize it. That's what they put in here that they're trying to say is a warning, which is anything but. And then they come to you and say, oh, well, that solves it. That solves the problem. It's inconsistent. And ladies and gentlemen, I'm going to turn it over to Mr. Parker to let him finish. Again, I just want to thank you for your focus and attention this trial. It's been greatly appreciated.